All right, Deputy McLeish, do we have anyone that's ready in the jail?
Yes, Your Honor. We have Mr. Wilson and his client. However, I think there was a witness that was supposed to be present in the courtroom. So I guess his preparedness or his readiness is dependent on the presence of the witness.
I do believe we have a witness. Is anyone here intending to testify? And what is Mr. Wilson's name? His client's name?
Is Caitlin Dennis, Your Honor.
Thank you, Mr. Wilson.
Say it again.
Caitlin Dennis, and the witness I'm expecting is Miss Stacey Cataract.
Stacey? All right. Yes, ma'am. If you'll come up to this table, if you look through that. Just have a seat at this table right here. And ma'am, will you go ahead and spell your last name for me? Cataract, is that right? All right, your first name's Stacey. Is that with EY or IE? EY? All right, this is in writ number WR22-8. And Mr. Wilson, is this a writ seeking bail reduction or is this a probable cause?
Bail reduction, Your Honor.
Bail reduction, okay. All right, and are you going to also call your client for purposes of this hearing?
Yes, Your Honor.
All right, so at this time, Ms. Dennis, I'm gonna have you raise your right hand so I can place you under oath. And Ms. Cataract, if you'll go ahead and raise your right hand also, I'm gonna swear both of you at the same time. Do each of you ladies swear that the testimony that you give the court today in this matter will be the truth, the whole truth, and nothing but the truth? So help you God. Ms. Dennis?
Yes, sir, Your Honor.
All right, Ms. Cataract?
Yes, sir, Your Honor.
All right, you may put your hands down. Who do you want to call first, Mr. Wilson?
We'll call Caitlin Dennis first.
All right, Ms. Abraham, if you'll go ahead and read that laptop down. That way, when she's ready to testify. All right, go ahead, Mr. Wilson.
Could you state your name for the record, please?
Caitlin Dennis,
And you're currently in custody. What date were you arrested?
January 13th,
And do you know what your bond amount is?
25,000.
And do you know what the charge is?
Criminal activity.
Engaging in criminal activity?
Yes, sir.
All right. And you mentioned it's a $25,000 bond. Are you able to make that bond at this time?
Yes, sir.
Prior to being arrested, were you working at all?
No,
Do you have any assets that you could sell? Cars, jewelry, anything like that?
sir.
And have you attempted to contact any bondsmen to see what it would take to post a bond?
Yes, I told my mother for East Texas bail bonds.
Okay. So you haven't contacted them, but your mother has. Is that right? Okay. And are you able to make that bond, that $25,000 bond?
No, sir.
Are you able to make any bond amount?
Yes. I don't know how much, so.
And Mr. Wilson, she's going to need to speak up. I'm having a hard time hearing her.
Yes, Your Honor, if you'll just speak up. Your Honor, did you hear the answer to the last question?
No, if she can repeat for me.
Okay. Are you able to make any bond amount?
Yes, I'm not sure how much though.
Okay. Okay. Your Honor, is that better on the volume?
We'll see. Go ahead.
Okay. And if you were to make bond, would you appear for all hearings and settings?
Yes, sir.
And would you comply with all conditions of bond and pretrial release?
Yes, sir.
And if you made bond, where would you go?
Rehab.
Okay. Well, let me ask that again. Where would you live? With your mom? And you mentioned you weren't sure the amount of bond that you'd be able to make. Are you depending on your mother to make the bond amount for you?
Yes, sir.
I'll pass the witness, Your Honor.
State any questions of Ms. Dennis?
I was muted, Judge. You tell everyone to unmute, but you didn't tell me. That's not right.
Well, I didn't know if you were going to talk or Ms. Heisel. I didn't want to be presumptuous.
Thank you, Judge. May I proceed? Now that it's unmuted. Ms. Dennis, you said you're arrested for engaging in organized criminal activity. Do you know what level of felony that is?
No, sir.
Okay, they didn't tell you? Did they not tell you, ma'am?
No, sir, they didn't. They just told me what my charge was.
And you said you were arrested on the 13th, is that correct?
Sir.
And you have no assets that you would be able to sell or mortgage in order to make a bond, is that correct? You're relying solely on your mother?
I'm going to live with her. Where I was living before I got arrested, I lost everything.
Did you own a house or are you renting a place?
Living with a friend. Me and my fiance were living with a friend. And right when I went to jail, I lost everything.
Stay with past witness, Your Honor.
Mr. Wilson, any further questions of your client?
No, Your Honor.
All right, do you want to call another witness?
Yes, Your Honor. The defense would call Stacey Cataract.
All right. Go ahead. I've already placed Ms. Cataract under oath, and you should be able to see her there on your screen.
Okay. And state your name for the record, please.
Sorry,
Could you just state your name for the record?
Stacey Cataract.
And how do you know Caitlin Lewis?
She's my daughter.
And are you currently working?
Yes, I am.
And are you willing to try to post bond for Miss Dennis?
Yes, I was going to try to help her get out. If it's possible for her to get out, I would try to post bond.
All right. And have you contacted any bondsmen?
I've contacted a few and they want 2,500 down, and it's just impossible for me to come up with that.
Okay. Is there an amount down that you could come up with?
Maybe 100 or two.
Okay.
I'm on a tight budget myself.
Okay. And so how many bondsmen did you contact?
Contacted 3.
3? Okay. And did all of them tell you $2,500 down?
Yes. One said they wanted 1,200 down and I can pay out the rest, but I don't want to get in debt with the payment plan.
Fair enough. And are you able to make those amounts?
I'm sorry?
Are you able to pay those amounts?
Yeah, I can't pay that amount.
Okay. And if Caitlin made bond, would you allow her to come live with you?
I'm sorry?
If Caitlin made bond, would you allow her to come live with you?
It's echoing.
If Caitlin made bond, would you allow her to come live with you?
Yes.
And would you ensure that she complies with her bond conditions?
Yes, if I can, because I live in Fort Worth, if I can get the bondsman down in Fort Worth, I can,
Okay.
instead of Canton.
Okay. And would you ensure that Caitlin appears at any court settings?
Yes, I will make sure she'll attend.
I'll pass it on.
Mr. Woodwhite?
Ms. Dennis, you said you live in Fort Worth?
Yes, I'm going to be.
I'm sorry. I didn't,
Sorry.
wrong. Ma'am, you said you lived in Fort Worth?
Yes, sir.
Okay. Is that in Tarrant County?
Yes, sir.
Okay. And you have transportation that would assist Miss Dennis in getting back and forth to court. Is that what you
Yes, sir.
said?
Yes.
Stay has no further questions, Your Honor.
All right, any further witnesses, Mr. Wilson?
No, Your Honor.
State, do you have any evidence or witnesses?
No, Your Honor.
All right, Mr. Wilson, would you like the argument at all?
Just briefly, Your Honor.
Go ahead.
Your Honor, this court has appointed me to represent Ms. Dennis in the case. In that order, it clearly finds that Ms. Dennis is indigent. Further, Ms. Dennis has testified that she cannot make bond in any amount, that she is solely relying on her mom. And her mom testified that she could probably pay $100 or $200 down, which would equate to about a $2,000 bond. And so her current bond is set at $25,000. It's unreasonable, it is excessive, and it is prohibitive of Ms. Dennis making bond. We would simply ask that the court reduce the bond to a level that Ms. Dennis could make.
Thank you, Mr. Wilson. Mr. Woodwhite?
Yes, Your Honor. Ms. Dennis has been in jail for 55 days. She's not entitled to bond under the delay statute. The state will proffer to the court that we have not received a case on this. I do believe there will be 2 grand jury sessions between now and her 90-day mark. State would ask that the writ be denied. just because we don't have a case, we're not 100% sure. Specifically what she is accused of, it's difficult for us to make cogent argument as to why her danger to the community and or flight risks, state is just unaware at this time.
And Mr. Woodward, sorry, Mr. Woodward, Wilson, are there any additional criminal history charges on Ms. Dennis that the court would take into consideration?
Part of the issue the state's going to have in responding to that is we have not been referred a case. I don't have her identifiers to pull her criminal history to see. State is unaware of any. So I can't, I would argue that the state would not argue that she does because we do not know.
Mr. Wilson, are you aware?
I'm not aware of any.
Say that again.
I'm not aware of any prior criminal history.
All right, court will take this under advisement and will issue a ruling at the end of the day.
Thank you, Your Honor.
Thank you, Your Honor.
All right, we'll be adjourning this hearing.
Your Honor, I believe that's all I had on the docket. May I be excused?
Yes, thank you, Mr. Wilson.
Thank you.
You're welcome. Mr. Smith, are you ready on, sir?
Judge, we're ready on all my clients, whichever you want to call.
We'll just go down the list. We'll start with Tessa Burr, CR 21124. All right, and I believe this is set today on a motion for continuance that's been filed by the state. I show that we're presently set for special setting on trial on, I believe, that date, May 2nd. We're scheduled to begin trial, and it's my understanding the state has filed a motion for continuance.
Yes, Your Honor. We have a necessary witness that is unavailable that specific week. We would request respectfully a setting either later that month or in a subsequent month.
All right, Mr. Schmidt, you want to respond?
Judge, obviously, we would object to the state's motion for continuance. Ms. Furr has been in custody over a year. We've been specially set since last, I believe, September or August. So this setting has been pending for quite a long time. Obviously, I understand the state's motion. That being said, we would ask that the court deny the motion for continuance and keep it set as currently scheduled.
If the court were inclined to grant the state's continuance, that may be contingent upon a couple of things. Mr. Schmidt, do you have your availability for May 16th available? I've recently had a civil jury trial that's 2 weeks after the setting that could alleviate the issue, but it'd be contingent upon your being able to be there.
Unfortunately, no, Judge. I submitted a vacation letter with your clerk today. I scheduled the vacation to take place after our special setting with Ms. Furr. I do know that was the issue, so I won't be available on that setting date. So it would have to be either the 1st of June or I do not prefer an earlier setting because of the way things have been scheduled. But I cannot do it the 16th of May.
Okay. All right, I will take the motion under advisement and I'll issue a ruling either at the end of today or tomorrow.
Thank you, Judge.
But right now, we'll continue with the case being set as scheduled on May 2nd.
Thank you.
You're welcome. John Horton.
Judge, I've asked that Mr. Horton not be brought forward. We're here on a status of competency. I do know that the last we were in court last month, I believe, Mr. Horton was on a on a wait list to get into Terrell, which was quite substantial. So at this point, from our perspective, we don't really have anything to announce except for that we're still waiting on his restoration process.
Yeah, so I've had a notation on my docket that indicates that Mr. Horton is number 574 on the list. So, all right, then, but you've checked on his personal well-being to the extent that you can as his attorney, and you don't have any other issues to bring to the court at this time?
Not at this time, Judge. It's my understanding that his mental status has not improved. I haven't heard report that it's deteriorated any further, but I don't believe that, based on my interactions with him, he's competent. And obviously, I expect it to stay that way.
Do you know, Mr. Schmidt, if Mr. Horton is a patient of the Injury Center by chance already?
Judge, I really don't know. I do know that I was initially appointed to represent Mr. Horton on some other charges that turned out to be minor charges. He was released on a PR bond, and then he was out maybe a month before he was rearrested on these more serious charges. In the short time that I was able to communicate with him, it did not appear as though he was in the position to get any sort of services. I don't know for sure because he couldn't really communicate as to whether or not he had been.
All right, well, we're trying to start a new program. We've seen some success with other inmates who were patients of the Injury Center with regards to getting them mental health medications while they're in the jail. And so if they were already an existing patient, then we could have a doctor come over and prescribe medications for them that could help lessen the deterioration rate while they're waiting for restoration. So anyway, it's just something I inquired about. Ms. Tabram just informed me that she's already checked into that and he's not. So,
Okay.
all right, so we'll set, but hopefully we're looking to go to Commissioner's Court on that soon to hopefully get that for all inmates, have that capability for all inmates going forward so that no one's sitting over there and just deteriorating, waiting to be 574 in the jail. So hopefully we'll have good news on that in the coming weeks. So for the time being, we'll set Mr. Horton in for another status. We'll set him out till May. And if you have your calendar available, I've got May 10th, 12th, or 24th. I'll let you have a pick if one of those is better than another.
The 10th should be fine, Judge.
All right, so we'll set him for a status update, and then on May 10th at 1.
And Judge, I know we try to send to Terrell State just because it's the closest in distance, but do we have any formal agreement with them as to if there's another facility available that has a shorter wait list? My understanding is they all have a long wait list. So I don't know that that's even a possibility, but what options do we have in that regard?
No, the state hospital is where they go. So they just go into the system, and if there were beds available, they would divert standing from Terrell State to somewhere else. So it's not that just that we're full, it's just that everyone's full and they service our region, is my understanding. All right, Avery Plunkett, CR 21-268-269. And Mr. Plunkett is set for arraignment. And do
That's correct, Judge.
you have a copy of the indictment?
We do received a copy of the indictment. Mr. Plunkett's name is spelled correctly. We'll wait formal reading, enter a plea of not guilty to both of the charges and ask that he be set for the pretrial.
All right, court will find that Mr. Plunkett has waived the formal requirements of arraignment. The court will enter his plea of not guilty on each charge and set pretrial on each matter. And I know I set you earlier today, Mr. Schmidt, for April 12th. However, I think we're at max capacity on that docket. So we can look to either April 14th or April 26th.
26 should be fine, Judge.
Okay. All right, we'll set Mr. Plunkett then for pretrial on April 26th. That will be at 1:30, Mr. Plunkett. If you're in jail, if you make bail, then it'll be at 9 a.m.
All right, sure.
Gerald Powell. Mr. Powell is set for pretrial, CR 21235.
That's correct, Judge. I do know the court will note that we've carried Mr. Powell's pretrial setting quite a few times. I do know that we filed previously a notice of intent to seek the insanity defense. I do know that Ms. Curry had requested independent evaluations, which is her right. I do know also that she had been in communications with third-party mental health professionals to get that done. The last we spoke, the mental health professionals were awaiting or seeking additional information. I'm not certain the current status of that at this point. I do know that Mr. Powell has not been evaluated at this point by experts for the state. Lastly, some months ago, we filed a motion to quash the indictment, which we've carried over pending the outcome of these evaluations. So from our perspective, obviously, we would ask for one of two things. Either we carry the pretrial for one more month, or we set it for a contested on our motion to quash. It doesn't matter. I think at the end of the day, both of those things have to occur. It's just a matter of timing. So the DA's office may be able to speak more clearly about the status of their evaluations.
And Judge, I'm not aware of an update. Ms. Curry is currently on a Zoom meeting with someone else. So I don't have a status update on that. I would defer to Mr. Schmidt if we think we're ready for the motion to quash hearing. I know he knows where him and Ms. Curry are in their discussions. So
And
Judge, I have no, go ahead, Richard.
I'm sorry, I didn't mean to interrupt you. I think at this point in time, if we set it for one more additional pretrial, I'll have to sit down and meet with Ms. Curry, hopefully in person within the next week or two. And we did that previously. I don't think that we're not off schedule necessarily. We're at the mercy of third parties. So we can just shoot for that April 12th date, and then I'll see if I can't make something happen or we can't make something happen.
Well, I've got an alternative proposal. We could either set it then, or we could set it later this month on the 31st. That's the evidentiary docket. We could kind of go ahead and set it to maybe be a pretrial then, and then if we need a contested hearing, we could do that in April. Kind of get you off the general docket. If you think March 31st too soon, other than that, we could go ahead today and set it for a contested docket on April 28th, which should give everyone.
I think April 28th is probably the wisest course. I doubt very seriously we'll have anything for the court before the end of this month, considering. So yeah, we could shoot for that April. Did you say April 28th, Judge?
April 28th, yes. And that would be at 1:30. That would be here in the courthouse. And so I'm just going to go ahead and I'll set it for the motion to quash.
Thank you.
And then we can take up the insanity issues at that time too. What was the date that we on Mr. Steele for Cruz?
I believe that's it for me, Judge.
Thank you, Mr. Schmidt. I appreciate you. Just for the record, cause number CR 2214, State versus Philip Sean Cruz. Mr. Steele met with Mr. Cruz today, filed a waiver of arraignment that was approved. Pre-trial is set April 26th. All right, Mr. Stevens, are you ready?
Yes, Your Honor, a plea on Jeremy Lewis.
All right, Mr. Lewis, if you'll step up, this is cause number CR 2180. State versus Jeremy DeCardo Lewis. Let me see if I have paperwork here. All right, Mr. Lewis, if you'll do me a favor, sir, and raise your right hand, I'm going to place you under oath. Mr. Lewis, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, may you put your hand down. Is your name Jeremy DiCardo Lewis?
Yes, sir.
And Mr. Lewis, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
And have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Bill Stevens. Are you pleased with his representation of you?
Yes, sir.
You feel like you've had enough time to talk with him about your case and have all of your legal questions answered?
Yes, sir.
Is there anything about this paperwork that you've read and signed today that you do not understand?
No, sir.
Mr. Stevens, do you believe Mr. Lewis to be competent today, and have you explained to him his legal rights?
Yes, Your Honor, he is competent and I have explained all his rights to him, sir.
You believe he understands them?
Yes, sir, I think he does.
Okay, I see here, Mr. Lewis, that you've been charged by indictment with a first-degree felony offense of manufacture and delivery of a controlled substance, Felony Group 1, greater than or equal to 4 grams but less than 200 grams. A first-degree felony in the state of Texas carries a range of punishment if convicted and sentenced of not less than 5 years in prison and not more than 99 years or life in prison. Do you understand that full range of punishment?
Yes, sir.
Okay, so that means any sentence that's handed down by a jury or a court must fit between that 5 to 99 or life range. And there's also an optional fine that could be imposed on you of up to $10,000. Do you understand that as well?
Yes, sir.
I see here that in this plea agreement that you've reached with the state, that you want to plead guilty to that charge in exchange for the state recommending that your sentence be assessed at 5 years confinement, which is the minimum, with a $3,000 fine plus restitution, court costs, reimbursement fees, and I think I may have said this already, a $3,000 fine. In addition to that, there are several cases that would be dismissed and taken into consideration today, those being a possession of marijuana, 4 ounces to 5 pounds, a few other manufacture or delivery of controlled substances, some misdemeanors, failure to ID, and evading arrest and detention. Is that your understanding of the plea agreement and what you want me to approve today?
Yes, sir.
All right, so understanding the plea agreement and the range of punishment, Mr. Lewis, I'm going to ask you, how do you plead to manufacture or delivery of a controlled substance in Penalty Group 1 greater than or equal to 4 grams but less than 200 grams?
Guilty.
Mr. Lewis, are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you, Mr. Lewis, to plead guilty today?
No, sir.
All right, the court will accept Mr. Lewis's plea of guilt. Mr. Stevens, any objection to the state's evidence?
No, Your Honor, no objection.
All right, state's evidence is admitted and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, only to note that all of these were a single criminal episode. So it is all one thing. State is also believes that a number of the cases that are being taken into consideration are duplicate charges. Just there does appear to be a lot of them. It does appear as though a number of them are duplicative in some form or fashion. We're just note that to the court. It does appear as though there are a lot of charges. It just doesn't appear to the state as though there should be quite as many. We're just resolving all of Mr. Lewis's business in one go. With that, we would rest and close.
Thank you, Mr. Lewis. Anything further from the defense?
No, Your Honor, rest in peace.
All right, I'm going to take just a moment and review the evidence. All right, court has reviewed the evidence. I find that there is sufficient evidence to convict Mr. Lewis of this offense. The court will follow the plea agreement that's been reached between the defendant and the state. Court hereby convicts Jeremy DeCarlo Lewis of manufacture or delivery of a controlled substance, penalty group 1, greater than or equal to 4 grams, less than 200 grams. Court assesses his punishment as a first-degree felony at 5 years confinement in the Texas Department of Criminal Justice Institutional Division. Orders him to pay a $3,000 fine, $180 restitution, $290 court cost, $70 reimbursement fees. Court also dismisses DA 2021-69, possession of marijuana, 4 ounces to 5 pounds. DA 2021-67, manufacture, delivery of controlled substance. DA 2021-66, manufacture, delivery of controlled substance. DA 2021-64, failure to ID, fugitive from justice. DA 2021-68, manufacture, delivery of controlled substance. DA 2021-71, evading arrest or detention. DA 2021-70, possession of controlled substance. Furthermore, the court awards Mr. Lewis 251 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Lewis, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you step over with the bailiff to be fingerprinted. Good luck to you, sir. Mr. Stevens, are you ready on Mr. Elder or Mr. Hilton?
I am ready on all of my.
All of your cases. Okay. Let's see here. Let's go with Lana Calder. Is Lana in the room? This is CR 22-3 and CR 21-322, State versus Lana Michelle Calder, and we are set for arraignment on the first-degree felony manufacture delivery, offense date alleged 11/4/21. We're set for pretrial matter on the other manufacture delivery, first-degree felony, date of offense alleged 5/16/2020. Are you ready to go forward on the arraignment?
Your Honor, I checked my discovery. I didn't have a copy of the actual indictment for the new case. I'll need to look at it through your screen. Different date. We're ready to go forward, Your Honor.
Go ahead.
All right. Ms. Calder would advise the court that in order to go correctly, she understands the nature and the consequences of the charges against her. We will waive reading of the indictment in her plea of not guilty.
All right, court will enter Ms. Calder's plea of not guilty into the record. Court will set cause number CR 22-3 and also cause number CR 21-322 for pretrial. Court will set those. Are you available on April 14th or 26th, Mr. Stevens?
April the 14th or whatever the day, Your Honor?
April 26th.
April 14th, Your Honor.
All right, court sets each case for pretrial on that date at 1:30.
Judge, I have also, just for the court's information and Mr. Stevens, the indictment was not properly sent to Mr. Stevens. I've rectified that. He should now have, he had the discovery, it just didn't include the indictment. I have fixed that. He should now have a copy in his discovery of the actual indictment itself.
Thanks, sir.
Yes.
There's a bond out front.
Yes, we have.
All right, Mr. Elder. This is cause number CR 21112, State versus Raymond Reese Elder, pretrial.
Yes, Your Honor, we have no formal pretrial matters, and we would like to set this for a plea.
Okay. And is there a certain amount of time that you need? Or
No,
is
sir,
it-
not really. If you'd set it out maybe a month or something like that would be good, so I can, get with the family, and I do need to go see him again in jail and whatnot.
What if we set it on March 31st? It's not quite a month, but it's 2.5 weeks. It's on the evidentiary docket, but if it's going to be a plea, then perhaps we can get it resolved then.
That'll work, Judge. Are we gonna be at the courthouse at 1:30 that day?
Yes, that day we will be in the courthouse. Everyone will be in the courthouse that day. So, all right, we'll set Mr. Elder then for plea on March 31st. And that'll be at 1:30.
Yes, sir.
Tony Hilton. This is cause number CR 2175, State versus Tony Leslie Hilton Jr.
Yes,
Set for arraignment.
It is, Your Honor. I have a copy of the indictment. I haven't shown it to him. Give me just 1 second.
Yes, sir. Take your time.
Your Honor,
Yes, sir. Go ahead.
my client would advise his name spelled correctly. He understands the nature of the consequences of the charges. We will waive reading of the indictment and plea of not guilty.
All right, court will enter Mr. Hilton's plea of not guilty into the record. We'll set this matter for pretrial. We'll set that on April 26th. Let's see, April 14th. waiting. This is cause number CR 2233 for the record. Tyler Buchanan McCaslin set for arraignment today. Attorney Mr. Logan Sawyer has filed a waiver of arraignment that's been approved by the court and pretrial set April 26th. Is that all you have today, Mr. Stevens?
No, Your Honor, I got two of them. Okay.
Blake Ekrit, CR 277. All right, this is a motion to revoke. Mr. Stevens, I believe that you've just been appointed today or very recently. So what the court will do is we'll reset this matter for a contested hearing. And I will set it on April 28th to give you time to get discovery, to meet with your client, prepare a defense. And if a resolution can be reached before then you can let me know and I can set you sooner. Otherwise, we'll prepare for that contested hearing on the 28th.
Your Honor, I'll be in Mexico on April the 28th.
Okay. Do you think you could be ready by the 31st? It's about 3.5 weeks. I'm sorry, 2. I'm sorry.
March. Oh, I was looking the wrong way.
It's not quite 3.5 weeks, a little over 3 weeks from today.
I don't know, Judge. I mean, I don't want to say no, but I don't want to say yes. I mean, I don't know what issues I've got with this.
Judge State has no objection to setting it for the 31st. And then if Mr. Stevens and I aren't able to settle this out by then, agreeing to reset.
Okay. All right, then let's set it on March 31st. That'll be at 1:30 here in the courthouse.
Yes, sir. I think that might take care of my business, Your Honor.
Very well. Thank you, Mr. Stevens. Good to see you.
Thank you, Judge. See you in a couple of days.
Thank you, Mr. Stevens.
Yes, ma'am, I'm ready.
Your Honor, that takes care of all the presents that we have physically present. I do have some of Mr. Ashmore's clients present. We're working on getting the rest of them.
Okay, I have Mr. Ashmore ready to go. So
Okay.
tell me who you have of his in the room.
What's your name, sir?
Lance McCormick.
Mr. Lance McCormick first.
All right, this is cause number CR 2234, State versus Lance Davis McCormick, and we are set for arraignment today. Mr. Ashmore. Had you lost you?
Judge, good afternoon. Mr. McCormick,
Yes, sir.
Your Honor, I have the indictment here. I had a chance to go over with my client. If the court would permit it, I'd ask if you have it, Judge, can we share screen with my client so I can go over it with him?
Yes, give me just a second.
Yes, Judge.
So I'm supposed to be done? Okay. Yes, ma'am. It says something about kind of bring up a screen to talk to the client.
There we go. All right, Lance, can you see that?
Yes, sir.
Okay, is your name spelled correctly? Lance Davis McCormick,
Yes, sir.
2 C's.
Yes, sir.
You see this first paragraph here? It's got your name again in this first paragraph, your name spelled correctly there, right?
Yes. Yes, sir.
Okay. Now you understand the allegation, and right now this is just an allegation against you, is that you possessed methamphetamine, more than 4 but less than 200 grams in Van Zandt County on or around October 18th of last year. You understand that?
Yes, sir.
You understand that there's also an allegation that this was in 1,000 feet of Canton Junior High.
Okay.
Okay. And Your Honor, if I could ask you to scroll down. There's a little paragraph.
Again.
You see that there, sir?
Yes, sir.
Lance?
Yes, sir.
Okay, and that's saying that in August 2017, there was a final conviction on burglary. Understand that?
Yeah, I understand that.
Okay. I'm going to assume that you're giving me authorization to waive formal reading of the indictment, enter a plea of not guilty, and negotiate with the state of Texas.
Say it again.
Lance, I'm sorry, it cut out on me. Lance, I'm asking your permission to waive the formal reading of the indictment, enter a plea of not guilty on your behalf. Is that all right?
Yeah, that's fine.
Okay. You understand it's a first-degree felony with a range of punishment, 15 to 99 years or life, okay?
Yes, sir.
Okay. Your Honor, I'd waive formal reading of the indictment. Mr. McCormick has confirmed his name is spelled correctly in the indictment. He understands the nature of the allegations against him. I have had a chance to visit with the state, but not yet with Mr. McCormick about how this may be resolved, and we'd ask the court to reset this for a pretrial hearing.
Mr. Ashmore, is there any way I can get a bond reduction?
We can talk about that not at this hearing.
Okay.
Yes,
sir.
we'll talk about that on the video visitation, but not at this hearing. All right, Lance?
Yes, sir.
All right, the court's going to find
Okay,
that.
thank you.
The court's going to find that Mr. McCormick has waived the formal reading of the indictment and the formal requirements of arraignment. Court will enter his plea of not guilty into the record. Court will set this matter for pretrial hearing on April 14th at 1:30.
I have a bond. No, I did not guilty, right? So I need to ask that by that or what? I'm still gonna have a bond even though I'm pleading not guilty, right?
This is just a formal hearing on the charges against you. Anything regarding a bond is not before the court at this time. We can certainly talk about that, but not at this hearing. And we should talk about that not on this Zoom call, because this is a live streamed hearing.
Okay, thank you, Mr. Ashmore.
Okay, thanks. Thanks, Mr. McCormick.
Mr. Shelton, you come on up.
Do you have Mr. Shelton, you said?
Yes, Your Honor.
All right, this is Donnell Shelton, CR 224748, also set for arraignment. Do you need me to pull those indictments up to you, Mr. Ashmore?
Yes, sir. I have them in my hand, but I don't have them on my phone where I can share screen, Judge. All right. Mr. Shelton, can you see that document?
Yes, sir.
Okay. Is your name spelled correctly? Donnell Giroux Shelton?
Yes, sir. I supposed to have one L though. Yeah.
Sorry, speak up just a little bit, sir.
I'm supposed to have one L and done that.
Okay, so you're confirming that Donnell is spelled incorrectly. It's one L.
Yeah, one L, sir.
Okay. And that same spelling on the fourth line down, that's your name, but it is misspelled. Your first name has one L, not two.
Yes, sir.
Okay. This is an allegation against you that on September 20, 2021, that you were convicted of manufacturing, delivering of a controlled substance, penalty group 1, in March 2005 in Dallas, and that there's an allegation that you possessed a firearm at a premises that you at a place you did not live in Van Zandt County, Texas. And then there's another paragraph that says, before the commission of the alleged offense in August 2009, there was a additional final conviction of manufactured delivery in Fort Worth, Tarrant County. You understand those allegations?
Yes, sir.
Okay. You understand that a third degree felony, punishment range 2 to 10, significant fines. You understand all those allegations, sir?
Yes, sir.
Okay. You authorize me to enter a plea of not guilty and negotiate on your behalf with the state of Texas?
Yes, sir.
Okay, Your Honor, with regard to CR 2247, we're going to waive formal reading of the indictment. Ask the court to enter a plea of not guilty for Mr. Shelton and allow our office to have time to visit with the state of Texas, which we've already done prior to this hearing. And we understand that a plea offer will be forthcoming from Ms. Curry shortly.
Mr. Ashmore, do you want to go ahead and go over the second indictment with him?
Yeah, yes, Judge. I was trying to see if I lost the Zoom signal or
No.
yes, if you could,
Yeah,
if the
I'm
court would kindly pull up 48. All right, Donnell, we're going to assume that your name, that the two places that we needed to correct it in the other indictment need to be corrected here, right? So your name has got 2 L's at the top of the indictment, and then 4 lines down. Again, your first name has 2 L's. It needs to be corrected to have 1 L. Is that right, sir?
Yes, sir.
Okay. All right, this indictment is a first degree, and just so we're clear, you understand that carries a potential range of punishment 5 to 99 significant fines. And that's based on the enhancements we're going to go over in a second, but you understand that punishment range, right? So,
Yes, sir.
okay. Now, these allegations say that around September 2021, you intentionally and knowingly threatened the complaining witness, a public servant, and that public servant, that police officer, was in the official, he was doing his official duties. You understand that allegation? I'm sorry, I didn't hear you, sir.
I'll read.
Mr. Shelton, is that a yes? It's cutting out on my end. I'm sorry.
I said I'll read. Well,
Oh, okay. I'm sorry.
I was looking at the complaint. 2 people. Understand what you're saying.
Can you speak up just a little bit? I'm sorry, Donnell.
I said I understand what you're saying.
Okay. And then you see, Judge, if I could ask the court to scroll down, there's 2 paragraphs here that we need to go through. First paragraph is at the bottom of this first page. You see that it says controlled substance penalty group 1. You can understand it?
Yes, sir.
Okay. And then there's another paragraph. It goes on to the second page. And I'll ask the court to scroll. And so Mr. Donnell Shelton can see that too, Your Honor, at your convenience. But Donnell, that basically says that In August of 2009, there was a final conviction for delivery of a controlled substance, penalty group 2 in Fort Worth, Tarrant County, Texas.
Yeah, I'll see that.
To not guilty and work towards the resolution of these matters on your behalf, correct?
Yes, sir.
Okay. Your reading of the indictment. Ask matter be set for a pretrial hearing. Led me and Mr. Shelton and the
All right, Mr. Ashmore, you're breaking up. I can't hear you, so I'm just going to take over right here. Court's going to enter Mr. Shelton's plea of not guilty into the record. We're going to set this for pretrial matter in each case, and we're going to set this for April 14th, and that will be at 1:30. If Mr. Shelton makes bail, it'll be at 9 a.m.
Judge, court would make an oral
Thank you,
motion.
Judge.
Maybe we should wait until a time where Mr. Ashmore can be more present, but I would make an oral motion to amend the indictments to correctly spell Mr. Shelton's name, which is Donnell, Donnel, striking the second L. As he has said, that is how his name is spelled. If the court would make that amendment to both indictments, the state would be most appreciative.
All right, court will grant this oral motion to amend the indictment to correct the spelling of Donnell Jerome Shelton to that of Donnell as the first name.
Thank you, Your Honor.
Court will have the original indictments amended to reflect that change.
Thank you, Your Honor.
Mr. Ashmore, are you still there?
Yes, Judge.
All right. Is Kendrick Willis in the courtroom?
He is, Your Honor.
All right. Thank you, Mr. Shelton. I've set your case for pretrial on April 14th. We'll see you then.
Mr. Come on, now, sir.
All right. Mr. Willis is set to enter a plea before the court. CR 19-211.
He is, Judge.
All right, Mr. Willis, if you'll raise your right hand, sir, and place you under oath. Mr. Willis, do you swear that the testimony you give to the court today would be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. Mr. Willis, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Mr. Willis, have you ever been diagnosed with any type of mental condition?
No.
And in this case, you're represented by your attorney, Mr. Casey Ashmore. Are you pleased with his representation of you?
Yes, sir.
Say again.
Yes, sir.
Okay. And do you believe that you've had enough time to review the case with him, have all of your legal questions answered?
Yes, sir.
Is there anything about this paperwork that you've read and signed that you do not understand?
No, sir, there's not.
All right, Mr. Ashmore, have you explained Mr. Willis's legal rights to him, and do you believe him to be competent today?
Yes, Judge. We've talked about this. Mr. Willis has been in our contact and in communication with our office for many months before this plea. He's successfully completed a great portion of Senecor before reporting back here to finish his business. And we have gone through his paperwork and his course of continued recovery as he's discharged from the Van Zandt County Jail and placed on probation. In fact, we had a lengthy conversation about it again this morning, and he just wanted to confirm all of those matters.
All right, Mr. Willis, you are charged by indictment with a third-degree felony offense of driving while intoxicated, third or more. If convicted and sentenced, that case would carry a range of punishment of not less than 2 years or more than 10 years confinement in the Texas Department of Criminal Justice and a fine of not more than $10,000. I see here that the plea agreement is that you're going to plead guilty to that charge in exchange for the state's recommendation that your sentence be set today by this court at 10 years confinement in prison, with that sentence being suspended and you being placed on probation for a period of 5 years, receiving a $1,500 fine plus court costs and reimbursement fees. And the state would be dismissing an unfiled misdemeanor driving while license invalid. Mr. Willis, is that your understanding of the plea agreement?
Yes, sir.
All right. So at this time, Mr. Willis, I'm going to ask you, how do you plead to driving while intoxicated, third or more offense?
Guilty, sir.
And Mr. Willis, are you pleading guilty because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
Court accepts the defendant's plea of guilt. Mr. Ashmore, any objection to the state's evidence?
No, Your Honor.
State's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state,
No, Your Honor.
from the defense?
No, Your Honor.
Take just a brief moment to review the evidence. All right, the court reviewed the evidence and I find that there is sufficient evidence to convict Mr. Willis. The court will follow the plea agreement in this case. The court hereby convicts Kendrick Willis of driving while intoxicated, third or more. The court assesses his punishment today at 10 years confinement in the Texas Department of Criminal Justice. The court suspends that sentence, places Mr. Willis on 5 years community supervision, orders him to pay a $1,500 fine, $290 court cost, $915 reimbursement fees. Court also dismisses under section 1245 of the Texas Penal Code M19-387, a driving while license invalid. And I believe that that's going to resolve it. So the court hereby remands Mr. Willis to the custody of the Banton County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. Mr. Willis, I'm going to have you step over with the bailiff to be fingerprinted on the judgment. After that, there's probation officers in the room that'll give you more information.
Thank you.
Sir, step on over with me, please.
Good luck, Kendrick.
Thank you.
And Your Honor, we do have Mr. Henry in the room as well.
Okay, if you'll go ahead and bring him up. All right, this is State versus Jesse Wagner Henry, CR 2341, CR 2168. We are set for pretrial on each matter. Go ahead, Mr. Ashmore.
There it is. Sorry, Judge. We do not believe, we don't have any pretrial motions before the court. We do not anticipate that we are going to bring any, Your Honor. I have visited with the state of Texas. We have a plea offer, which I have been unable, unfortunately, to communicate with my client prior to this hearing, that there would be a 5-year straight probation offer, $2,500 fine on the 168 family violence, third-degree felony, and a 1245 on the bail jumping. I'd ask the court to reset us for so that we can continue to negotiate and visit with my client to see if we can resolve this business without the need of a final trial or any other further hearings.
And Mr. Ashmore, you cut out, so I didn't hear what you said on. You want me to reset you for what?
For a docket call, Your Honor, I'm sorry. So to see if we can resolve this and so I can visit with my client about this offer that I received from the state yesterday. And if that wasn't clear, 5-year straight probation, $2,500 fine on the third-degree felony family violence, and a 1245 of the bail jumping case.
All right, the court will set Mr. Henry for a docket call on April 14th. That will be at 1:30.
Thank you, Judge.
right, Ms. Boyd, if you'll step up. All right, this is cause number CR 21280, State of Texas versus Brittany Liddell Boyd. Ms. Boyd, if you'll raise your right hand, I'm going to place you under oath. Ms. Boyd, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, make sure you speak directly into that microphone. All right, Ms. Boyd, are you a United States citizen?
Yes.
Do you read, write, and speak English?
Yes.
Have you ever been diagnosed with any type of mental condition?
Yes.
What have you been diagnosed with?
Like depression, anxiety.
Okay. Are you currently on medication for any of those?
No.
Are you under doctor's care for those?
No, not at the moment.
Do you feel like the fact that you're not on medication or under care for those is in any way inhibiting your ability to understand the proceedings today?
No.
In this case, you're represented by your attorney, Mr. Casey Ashmore. Are you pleased with his representation of you?
Yes.
Okay, you hesitated. If there's an issue, I need to know about it.
No issue.
No issue? You sure? Okay. And do you feel like you've had enough time to discuss the case with him and have all your legal questions answered?
Yeah. Yes, sorry.
Okay. Is there anything about this paperwork that you've read, signed today that you do not understand?
No.
All right, Mr. Ashmore, do you believe your client to be competent today, and have you explained to her her legal rights?
I do. And yes, I have.
Okay. All right, Ms. Boyd, you are charged by indictment with a state jail felony offense of possession of a controlled substance of penalty group 1 less than 1 gram. If convicted and sentenced, that carries a range of punishment of not less than 6 months or more than 2 years in prison and a fine of not more than $10,000. I see the plea agreement in this case is that you would plead guilty to that charge. In exchange, the state's recommending that the court defer a finding of guilt. That means that the court not convict you today of this offense, but rather the court defer that finding and place you on community supervision for a period of 2 years. You'd also be ordered to pay a $2,500 fine plus court costs, restitution, and reimbursement fees. You understand that to be the plea agreement?
Yes, sir.
Are you asking the court to approve that today and place you on community supervision?
Yes, sir.
You understand that if the court approves that and places you on probation, if later you violate any of the terms of your community supervision, the court could conduct a hearing, and if the evidence proves that you violated, the court could adjudicate your guilt, convict you of that offense, revoke your community supervision, and could assess your punishment anywhere from the minimum 6 months to the maximum 2 years.
Yes, sir.
Understanding both of those things, you still wish to plead?
Yes, sir.
All right, Ms. Boyd, then how do you plead to the charge possession of a controlled substance, penalty group 1 less than 1 gram?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
All right, the court accepts the defendant's plea of guilt. Mr. Ashmore, any objection to the state's evidence?
No, Judge.
All right, state's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, at this time we would rest and close.
From the defense?
No, Judge.
All right, I'm going to take a moment to review the evidence. All right, the court's reviewed the evidence. I find that there is enough evidence to convict Ms. Boyd of this offense. The court will follow the plea agreement. The court hereby defers a finding of guilt, places Ms. Brittany Liddell Boyd on deferred community supervision for 2 years, orders her to pay a $2,500 fine, $290 court cost, $535 reimbursement fees, and $180 restitution. All right, Ms. Boyd, you hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm gonna have you step forward here to be fingerprinted by the deputy. Ms. Burns, do you want me to send her over to the department?
Yes, please.
So, Ms. Boyd, after you get fingerprinted, we're gonna get you a copy of that judgment there along with your conditions. And I want you to report over to the probation department. You'll take those things to them, and they'll process you in over there and give you more information. And that's gonna be located 2 blocks north of the courthouse, behind this little restaurant over here, behind the mobile station. So there's a courthouse annex over there. You'll go in there and you'll go to the Community Supervision and Corrections Department. That's the probation department. Okay, all right.
Still need Barley.
Michael Barley?
Yes. Okay,
Mr. Archer,
Evert.
Ms. Femme, you can go. Just have a seat in the hallway, and Ms. Taberham will bring you a copy of those documents. Once you get those, then you'll go across to the Van Zandt County Probation Department. Okay?
Judge, may I be excused?
Yes, thank you, Mr. Ashman. Mr. Harden, are you
Thank you,
ready?
Your Honor.
I understand, Judge, my serial number provided to the officer, over to jail, and I haven't seen it.
Oh, okay. State, do we have the revised paperwork for Mr. Sistrunk?
Your Honor, I have the disposition ready to go. I have the judgment pulled up, but I still have not been provided by anybody with the information on the gun to amend the judgment.
So who has the information on the gun?
I haven't had any contact with that.
I can't hear, Judge.
Yeah, come on up. Just right there on that microphone right there. You'll see.
Yeah, yes, ma'am. I have the serial number on the.
And
on
go
the
ahead and take
shot.
that toothpick out of your mouth.
I have the serial number on the shotgun that will be taken in place of the one that you have now.
Judge,
I have-
I'll leave it to you, Judge. We are live on YouTube, so I don't know that we want to share a serial number over YouTube. If somebody from the court could email that information to me, or perhaps we just take it off of YouTube to get the serial number over Zoom, whatever the court would prefer.
All right, Mr. So if you'll have the client write down the serial number and bring that to me. Here, if you need a sticky note.
Yes, sir.
And if the model, if you have the model and serial number, we'll just write that on there. Get that way. All right, I've given that to her. Let her revise the judgment. I'll call you right back. It's gonna take a minute, you gotta see.
Did not have access to it today. And all that. Or they're running a background check. So that exchange could occur.
Yeah, that's my understanding is that Mr. Sistrunk has coordinated that with Deputy McLeish.
Yes, sir. Yes, sir. There's supposed to be some kind of documentation saying that they would release the one they have in possession now, because after today, the state won't be involved with my case. So they said they would give me a form of saying that they would release what they had.
Okay. As
And
soon as
Judge, I've printed to Miss Peggy's printer the new front page of the judgment with that surrender and destruction order, as well as the disposition that Mr. Sistrick will need a copy of to receive the rifle back.
All right. Might as well state it, Mr. Sistrunk. So I think she's got it. She just printed it. All right, this is number CR 21-189, State of Texas versus Tanner Garrison Sistrunk. Mr. Sistrunk, if you'll raise your right hand, I'll place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. And Mr. Sistrunk, are you a United States citizen?
I am.
Do you read, write, and speak English?
Yes, sir.
And Ms. Heisel, I'll need the order, the special order language on the back page of the judgment.
Okay.
So there's a clause that goes in there that actually says that it's ordered versus just being a term of the plea bargain.
Okay, let me check with Miss Abney on the language of that, see if she has that pre-made for me.
I believe she does. Mr. Sistrunk, have you ever been diagnosed with any type of mental condition?
I have not.
And in this case, you're represented by your attorney, Mr. Ron Harden. Are you pleased with his representation of you?
I am.
Feel like you've had enough time to discuss your case with him and have all your legal questions answered?
Yes, sir, I have.
Is there anything about this paperwork that you've read over and signed today that you do not understand?
No, sir.
All right, and Mr. Sistrunk, I see that you've been charged with by indictment with a second-degree felony offense of aggravated assault with a deadly weapon. But the terms of the plea agreement would be that you would plead guilty to a Class A misdemeanor offense of deadly conduct, and the state would be recommending upon your plea of guilt that your punishment be assessed at 10 days confinement in the county jail. You would receive 1 day credit towards that sentence. You would have 9 to serve, and you would serve that out as agreed on predetermined times. And you are agreeing to the surrender and the destruction of a firearm. In addition, you would have fine, court costs, and restitution and reimbursement fees. Is that your understanding of the plea agreement?
That is my understanding. Yes, sir.
Mr. Harden, do you believe your client to be competent today, and have you explained to him all of his legal rights with regards to the case?
I have, Your Honor, and I do.
All right. Mr. Sistrunk, at this time, I want to ask you, how do you plead to Class A misdemeanor deadly conduct?
Be guilty.
And Mr. Sistrunk, are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
All right, the court hereby accepts Mr. Sistrunk's plea of guilt. Mr. Harden, any objection to the state's evidence?
No, Your Honor.
All right, state's evidence is admitted and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, just that I am printing that back page with the special findings.
Okay. Anything further from the evidence? All right, court's going to review the evidence. At this time, I'm going to go ahead and tender to the bailiff that is a disposition form that you'll need to retrieve the weapon. So we're going to give that to you here momentarily. Show that to Mr. Horton.
The battery shows to be running low on this laptop here.
Okay. Thank
Like,
you.
I guess I'm the last one.
We'll come tend to that pretty quickly. All right, court's reviewed the evidence. Court finds that there is sufficient evidence to convict Mr. Sistrick of this offense. The court will follow the plea agreement in this case. The court hereby convicts Tanner Garrison Sistrick of deadly conduct, Class A misdemeanor, sets his punishment at 10 days confinement in the Van Zandt County Jail. The court will order him to serve the remaining portion of his sentence, to which he does not have credit, on the dates and times specified in Exhibit A for the special order of committing to jail. The court will give him 1 day credit towards his sentence, order him to pay a $1,500 fine, $270 court costs, and $35 reimbursement fees. The court's going to order the surrender and destruction of Remington 1100s with the following serial number as indicated on the judgment. So, Mr. Sistrick, when you go to turn yourself in to serve your jail time, it's going to be important that you do two things: that you bring a copy of the order that says that you're supposed to be there, and bring picture ID with you. Otherwise, they won't let you in the jail.
And that will be just in the main lobby front office, or will I have to go around to the?
No, you'll go into the main lobby and just tell them who you are and what you're there for. You'll present that order that has the times and the dates and my signature. And you'll also present your photo ID so they'll know that you're not sending someone else to serve your jail time.
Will I receive that paperwork for documentation today?
Yes, yeah, we'll give you a copy before you leave. And Ms. Heisel, did you send one over?
I did, Judge. If it did not print, I can try resending that.
Let me check. I've got 3 here, but I'm not seeing it. This is the cover page. I think we only got page 1. We only got page 1 on that one. Sorry.
Let me resend that last page for you, Judge. All right, Judge, it should be printing to the clerk's printer.
All right, Mr. Sister, hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you come forward to be fingerprinted. And then after that, you have a seat in the hallway and Ms. Abraham will bring you a copy of the order for commitment and the order that you'll need to take with you to the jail. Okay, so come on up here, you'll be fingerprinted. Yeah, have a seat in the hallway right there. She'll bring it to you. Yes, thank you, Mr. Thanks for sticking it out with us today. That was Mr. Wilson's conference. April 12th. All right, do we have Mr. Knowles' clients?
Yes, Your Honor, we do. Ms. Ebert, come on up. Both of Ms. Marley, you too, yes, sir. Sure, podium, please.
This is cause number CR 18473, State versus Bobby Ebert, and also cause number CR 21225, State versus Michael Marley. Ms. Ebert, Mr. Marley, Mr. Knoll has contacted the court, indicated that he is detained in Dallas County Court and he's unable to be here today. So I'm gonna have to reset your hearing. So I wanted to bring you up to tell you that so that you're not wondering what's going on with your case. So I show that Ms. Ebert, you are set on a motion to revoke hearing today. I'm going to reset you for a contested hearing on March 31st. So that's about 3 weeks or so. And Mr. Ebert, you are set on a status today regarding medical records. I'm just going to go ahead and set you for a status on that same date, March 31st. If you speak with Mr. Knoll and he's able to come to court sooner, I could bring you in later this week on the 10th. So what the plan is right now is I'm going to set you on the 31st. If you get a hold of Mr. Knoll and you want a hearing sooner, let him know, and I'll set you on Thursday. We'll bring you back in and have a discussion, okay?
Thank you, Your Honor.
Thank you.
You're welcome. You have a good day.
Okay.
Let's see, what date did I get Mr. Hollister this morning? Does anyone recall? 12th perhaps? You remember Mr. Woodwhite? That was Mr. Eastland's client. I didn't write down what date I set him for.
Who is that, Judge?
All right, so CR 21-293, State versus Philip, Andrew Hollister. The court had taken Mr. Hollister into custody today for violations of pretrial release. So I'm going to set that for, tell you what, I'm going to set that for a docket call because I don't know if that'll be a plea. So I'm going to set that for, I think I already did set that for April 14th. Is that correct?
I believe it was the 14th, Judge. That's what I wrote down.
So I just want to make sure that's reflected on the docket. I believe that concludes the court's docket. Looks like Deputy Police is already shut down, so I'm assuming there's nothing else they need. So that will conclude our criminal docket for court stay.
Judge, thanks for being patient with me on that paperwork. I tried to be the hero and do it myself instead of having Miss Abney do it, and we see how that turned out, so.
Yeah, if you want to, there's not much wisdom that I do have, but the wisdom that I do have is that legal assistants, especially experienced ones, are very, very valuable individuals.
Yes,
It's best-
Stephanie knows best.
It's best not to get in their realm unless you display your lack of knowledge and skill to what they do. So I've been there,
Absolutely.
and I learned my lesson the hard way as well, but I am proud of you.
Thanks, Judge. We'll see you later.
Have a good day. See you, Mr. Woodward.